What if they did a week ago? Those sorts of questions. The one takeaway on the first point that I would make is an employer can enforce a drug-free workforce. And in most instances, you would expect that that's probably what employers would want to do. Although again, it may depend on the particular employer. Certainly there's some out there that might think a little usage during the job might increase creativity, who knows? But for most purposes, it is appropriate and acceptable for employers to prohibit marijuana use on the job. Next question, can employers drug test their applicants for jobs or their employees? Now, first point is some of this falls under federal rules, federal regulations. Of course, you've got DOT, regulations, drivers, airplane pilots, things like that. Yes, that law would still certainly apply. Missouri law specifically, it does not prohibit drug testing employees. That is something, there's nothing in the statutes in Missouri that say that employers cannot do that. And again, I would certainly point out certain jobs still would require and mandate drug testing. Also, issues that might come into play are union contracts. What is called for in the union contract? What is called for under state or federal regulations for that particular job? The Missouri law also specifically prohibits, of course, operating a motor vehicle, aircraft, or boat while impaired. And again, they use the language while impaired. So does that bar or ban an employee, again, from engaging, participating in marijuana use a week before he or she, gets behind the wheel of the bus or in that airplane cockpit? Not quite clear, but I would certainly suggest that employers can make reasonable restrictions and bans even of use or potentially even being under the influence while on the job. A couple of takeaways, on this point, employers can drug test applicants or employees. In doing that, I would certainly recommend that all employers, if this is an issue, you have a clear drug test, drug use policy. Certainly, if this is an important issue for you as an employer, you should have an anti-drug use or anti-use on your premises and a specific clear policy on that. And then also, if you want to take it to the next step of prohibiting applicants from and checking their drug test to see even if they have it in their system, you have a clear policy to do that. Obviously, if you have a clear policy, the next step is please make sure you follow your policy. So often employers do get into trouble because, and maybe they think they're being nice or trying to accommodate someone or a long time worker that everybody likes or is a good friend of the owner, and we'll treat Bob in this situation a little bit different. Well, lo and behold, what's going to happen. It might be the employee you don't quite like as much or looking for a reason to get rid of, but that person has a similar issue, looks for a similar accommodation, and they're inevitably going to say, well, wait a minute, you treated this guy differently than you're treating me. That's where you get into trouble. So have a policy, follow your policy, and have a non-discrimination aspect to your policy. Yeah, Ted.
So in Missouri, let's say if a person is not in a sensitive safety position, not a bus driver or anything like that, they test positive, get a drug test policy, but you cannot demonstrate that they were ever under the influence of work. If you turn it.
Now, good question. So the question for those at home, if they didn't hear it, the question is whether someone tests positive but weren't necessarily impaired. I believe that yet as part of a drug test policy, that person did test positive, and if there's action that can be taken. And in Missouri, it's still a little bit unclear. The law doesn't specifically state in Missouri whether you have the right as an employer to take action against an employee or prospective employee because that person tested positive. And of course, the issue is, we have to look at this. Marijuana, I guess studies show it could stay in your system and show up for possibly 30 days. So the employee in that setting can say, hey, wait a minute, I was at a party, 29 days ago, and I got secondhand smoke from it, that sort of thing. So it's a little bit unclear in Missouri. The lesson or the suggestion I would make in that situation just goes back to follow that policy. Have a policy, and if your practice is and you want to make it a point that, look, even if someone just tests positive, it's important enough to us as an employer to not have any risk. We don't want people, even doing it medically on the side with a doctor's note 20 days ago. Have a policy and then stick to it. But again, the law's a little bit still unsettled in that area in Missouri.
And I'll just add one thing too. If you haven't, you can also ask your employees in Missouri if they've gone through the process of getting their Missouri medicinal marijuana card. That may be a question to ask them if they do have a positive test for marijuana. But like Richard has talked, then that implicates an EDA, and now you know that they're smoking marijuana to cover up or to assist them in a disability. So it really does kind of always go back into that ongoing dialogue, I'd say.
Another takeaway, if this is an issue for particular employers, again, like a lot of things in the employment setting, it goes back to documentation. We'll all talk a lot about having a policy and following it, staying consistent, but then next is the documentation. What are your findings? So I would suggest, train your managers, train your supervisors to look for signs of impairment. Obviously, if someone is impaired, they don't have a right to be there on the job. So look for those signs, whether it could be lethargy, red eyes or off balance, confusion, lack of focus. They've got, orange hands from eating the Doritos all day long. They've got the munchies or eating brownies, whatever it is. But train your staff, look for the signs of possible impairment. And then next, document your observations. And I would strongly suggest you train staff and managers, document what they saw. Don't document conclusions. Don't document Bob was impaired. Well, no, we don't know what that employee might say. You might just say, I didn't sleep very well last night. But document, have your staff and your managers document their observations. The employee was, tired. He or she had his head down at his desk. They showed some difficulty walking. They had red eyes, confused speech, those sorts of things. They were off balance, those sorts of things. So take a close look at that, and that's what I would encourage people to record. As I said, the law is still evolving. I mean, in Missouri, it's only been in place for 2 years now, a little over 2 years, I guess 3 years now. It's still evolving. It's going to continue to evolve. The laws are going to change, I'm sure, as these issues become more and more widespread. One of the questions Megan just pointed out is whether an employer can ask an employee, or maybe more likely a prospective employee, if they are a medical marijuana user. And that does bring up some other interesting issues. Generally, the rule would be, no, you don't have a definite right to ask about health issues. Now, if it is something germane to that job and they have to meet certain physical requirements, or they have to have a DOT physical exam or doctor certification to do certain jobs, certainly you can do that. But as a general matter, do all employers have the right to ask their employees health-related issues? And the answer is no. And of course, HIPAA would still apply. So can you ask your employee if they are a medical marijuana user or card holder? And unless there's some specific documented reasons set forth with that job, I think there's a pretty strong argument. Again, it's unsettled, but still a pretty strong argument. The answer will be no, that you're going to get into HIPAA violations, because then you are asking, at least in Missouri, you're asking for medical information. Now, it's different if the employee comes forward and says, look, I want an accommodation. Do we have to accommodate employees for them asking to use medical marijuana on the job site? And then absolutely you can ask, number one, you need to see, the doctor prescription, the medical marijuana card. And I certainly think you can ask some questions about the use in order to document and support the accommodation being sought. So moving forward and trying to go through, again, a couple of recommendations. Have a clear drug policy. I mentioned that. And again, I would broaden it to not just for marijuana. Certainly that's in the news a lot and getting more and more prevalent, but any other substances. I mean, you may have a policy. Do you need to have a policy on somebody using Vicodin or hydrocodone or morphine or some of the heavy dose narcotics while they're on the job? That could probably be, and some would suggest, far more impairing than maybe even medical marijuana might be. So I would make sure you have a drug policy and make sure it addresses more than just marijuana. As I mentioned earlier, enforce the policy. Absolutely very important in a non-discriminatory manner. I would strongly suggest educating employees about the signs of impairment, what they should be looking for. As I said, document your findings with with factual observations, not conclusions. And then also, I would have a clear job description, documented job description for each job in your business. That way, there may be reasons why certain jobs, one definitely cannot be even have it in their system, and we want to avoid that. But again, the job descriptions would go a long ways toward supporting you in that respect as well. So sorry, we're trying to keep things moving along. A lot of materials to cover. If anybody has questions, also at any of the breaks, all of us, as well as all the speakers are around to talk and answer questions during any of the breaks or even after the seminar this morning. Next up, Megan's going to talk about some of the legal trends in the employment area.
Okay, hi everybody. As Tom mentioned, I'm Maggie Genson. I'm one of the partners here at Fox Smith. Richard got to give his war stories and Tom got to talk about weed, but now I'm going to talk about the updates in the law, which is not always the most exciting things. So real quickly, the reality is that COVID-19 has really impacted the federal laws and state laws that have come down. We're seeing guidance from OSHA, from EEOC, executive orders, and the state laws are kind of being overshadowed by that. And Stas and Sarah are really going to give us a good update on the status of COVID-19, especially the mandate for the vaccines, which I'm sure a lot of you are curious about. But I do just want to touch on a couple high points about federal law, Missouri law, and Illinois law. So first, under the federal law, some of you may remember that President Biden did issue an executive order related to non-competes earlier this year. And that executive order is still waiting to be pushed through Congress. There is no federal law yet in place about restricting non-competes. But what his executive order really did do is kind of created this groundswell of state law that started impacting non-competes and the use of non-competes for employers. And Illinois is one of those states. They have enacted laws really restricting non-competes as to income levels and when they can actually be used. So it's anticipated whether that will actually happen with infrastructure legislation and everything else coming down, whether or not this act will kind of come to fruition or not. But I think to the extent that you are an employer who uses these non-competes to really, it's something that you kind of want to watch. It's one of these trends that you do want to stay on top of. So real quick, I'm going to switch over to Missouri law. For our City of St. Louis employers, this year, the City of St. Louis did enact a ban the box ordinance. They're following the kind of trend of all of the other jurisdictions in the state of Missouri. So what is the ban the box legislation? Basically, if you are still asking on your employment application whether or not you have been arrested or convicted of some type of crime, you need to take that off. I would say that's true even if you are not in a jurisdiction where they have the ban the box ordinance. You don't want to have to get into that dialogue and really have that conversation with the employee. So for the ban the box in the City of St. Louis, it only applies to employers with 10 or more employees. So like Richard mentioned, all of these laws apply in various different capacities with various different employers. So it can be confusing. I don't disagree with that. The one big thing too that for the City of St. Louis is obviously you can't base a decision on an employee's conviction record unless it's directly related to the job that employee is going to be doing. So that is kind of the language that tracks a lot of the other jurisdictions. But the one thing that is interesting is once you've determined, okay, I've got my final applicant pool, I've got 4 people who I think are great. Well, one of these guys I kind of question, so I want to look into his criminal history. Sure, go ahead. You can do that at that point, but you also have to look into the other 3 employees' criminal history. So once you've got your final applicant pool, make sure you're looking at everyone, not just one of those employees. And moving to this Victims Economic Safety and Security Act, you've probably seen this or heard about this in the news. It really is a national trend. It's affectionately referred to as VESA laws. Illinois has a VESA law, and it's geared at protecting employees who are victims of domestic or sexual assault and kind of sexually violent crimes. And Missouri, rather surprisingly, I guess, is on one of the forefronts of this issue. This law was actually just enacted August 28th. It was signed by the governor. So what the law will do is if you are an employer with 20 or more employees or 20 to 49 employees, you are required to give employees who are victims of sexual assault or domestic violence 1 week of unpaid leave. If you are 50 or more employers, it's 2 weeks of unpaid leave that you need to give to your employees who fall within this kind of definition under VESA. And also, it tracks similarly to the FMLA, where somebody's out of the office. When they come back, they've got to be put right back in that same position. And that's the same for Illinois. Missouri's VESA law is narrower, Illinois' law is broader, and that's been enacted actually for, I think, two years, but it was recently amended earlier this year. One of the biggest things I will say is under Missouri law, this VESA law, you have to, as an employer, give notice to your employees by October 27th of this year of the enactment of the VESA law. In other words, hey, employee, if you have been a victim of this, if you are suffering with it, if someone in your household is suffering from it, then you are eligible for this 1 week of unpaid leave or 2 weeks of unpaid leave. So that's by October 27th. You're supposed to do that. And then obviously when you hire new employees, you make them known of that. And what's the easy way to do that? By putting a VESA policy into your handbook. So to the extent you haven't updated your handbook for 2020 or for 2021, geez, I already lost a year because of COVID. For 2021, you want to make sure that that is included in your handbook, and kind of moving forward for 2022, making sure that a lot of these laws are also included in your handbook. The other thing for the VESA law is the Missouri Department of Labor does require that you put a poster in a common area at the place of employment. You can go onto the Department of Labor's website, grab it, post it in the common area where you have your other, anti-discrimination posters, but that is an additional requirement. There's some great secondary sources online about VESA and the implications of it, or obviously feel free to give any of us a call and we can talk you through the requirements. But Fox Smith, actually one of our attorneys, Pete Cosgrove, who can't make it today, we sent out, and it was on our website, but about this assumption of risk warning. And under this warning, it was Senate Bill 51, it was signed by Governor in July of this year. It pertains to COVID. So if you are a Missouri employer and you see this warning on this PowerPoint, just stick it up in your place of employment. What it does is create a rebuttable presumption that I came in here and I knew I could potentially get COVID and I got COVID. So it just limits the potential liability. As with every law, especially in employment law, there are exceptions to that, but you have to actually prove that you got COVID in that place and that was the results of this, injury. So it's a pretty high bar to meet. So if any takeaway, just stick that up somewhere at your place of employment to try and minimize your liability.
Maggie, does that apply to employees as well as customers?
It applies to, yes, to both. So, and then quickly, I want to just touch on, Richard's already went through sexual orientation in Missouri and in Illinois, so I'll skip over that, but a little horror story about attorney's fees. As most of you may know, the Missouri Human Rights Act, and the Illinois Human Rights Act affords attorney's fees if plaintiffs are successful at trial. Okay, so you have to get all the way to trial. Plaintiff has to be successful at trial, and if they are, then the defendant will pay their attorney's fees. Well, recently, 3 weeks ago, the Western District of Missouri Appellate Court upheld what's called a fee multiplier. What happened is a Jackson County, pretty straightforward gender discrimination case. Plaintiff was successful at trial, and their attorneys, plaintiff's attorneys said, hey judge, listen, this was a complex case. Because it was a complex case, I had to defer other business, And so I should be entitled to this multiplier. And their attorney's fees were like $350,000 that they had submitted. So that was multiplied by 1.5%. They got a lot of attorney's fees, more than the defense attorneys had earned, by their billable hourly rate. Well, and the trial court said, you know what, you're right. So I'm going to give you that multiplier. So you're going to get additional attorney's fees. And that was upheld by the Western District of Missouri. So we think it's anticipated that during settlement negotiations and as we move forward, we're going to hear, well, listen, I got a good case. And this is complex. And because it's complex, I'm going to have to defer business, which means your client may have to also be on the hook for a multiplier award. So just something in the back of your mind to kind of think of. I know we tell you guys that, oh, we have, the concern of attorney fees, but we're seeing these awards upwards of $500,000, which that's a chunk of change, especially when you have, an employee who maybe is only earning $30,000, $35,000. The attorney is going to be awarded more than their actual client. And then quickly, Illinois is one of the states, which I think is always true, that's actually the busiest when it comes to employment laws. And Richard did touch on sexual orientation. Obviously, that's a protected class now, specifically under the Illinois Human Rights Act. And it's not just whether I'm gay, I'm a lesbian, it's my bisexuality, my gender identity, transgender. It's a very broad provision as to how sexual orientation is actually defined. So just be wary of that. The other thing, and maybe I beat a dead horse on this one because I know I talked to clients a lot about it. I've spoken to people about it before in previous presentations, but it's the reminder that the Illinois Department of Human Rights requires annual sexual harassment training for Illinois employers who have one or more employees. So, and that was even before the Illinois Human Rights Act was amended for one. So if you are an Illinois employer, do your sexual harassment training. You don't have to submit anything to the Illinois Department of Human Rights. Just keep the PowerPoint, have your employees sign off on it, and keep it in a file so that you have it in the event you ever get questioned. But it's just an important thing that I think probably gets overlooked. And as Richard mentioned too, the Illinois Human Rights Act was amended, and some of these are from 2020 because I feel like I said, a lot of it was overshadowed. Some of them are from 2021. But that one employee is 20 weeks, right? If you have one employee who's working in Illinois for 20 weeks within the year of the discrimination or the year preceding, then they can try and file a civil rights violation under the Illinois Human Rights Act. And then quickly, I know I'm over time.
Even in Missouri,
Yeah.
training of employees helps you defend the case.
Absolutely.
You're getting sued, and you haven't done a training for your employees. There is no doubt that's going to come out in the case, and that is a strike against you as a Missouri employer.
Yeah, sexual harassment cases in particular, because that's the first thing we hear is, well, I didn't even know who I was supposed to contact, or I didn't know. And so giving them that training, having them sign off specifically on a sexual harassment policy, those are things you want to do. It sounds like a lot of paperwork, but the first thing generally we do when we get that is we go to your employee handbook and see, okay, how are we going to argue this? Where are our defenses going to be? So sometimes that employee handbook can be your first line of defense. And so it really is important that you keep it up to date so that in the event you need us, we've got it. The other, and one of the kind of last things I want to talk about is this Workplace Transparency Act, which I will say it's a real doozy. It covers a lot of different things for our Illinois employers. And I just specifically want to touch on a couple points, which is, I know we have a lot of employers and a lot of clients who use arbitration agreements. I know, Tom and I have defended them in Jackson County, Richard and I have defended them in federal court and on this side of the state. But what the Workplace Transparency Act does is it actually removes harassment and discrimination claims from arbitration agreements. So Illinois has said, no, you can't include those in an arbitration provision. So that's just something to remember if you do use them, to have it removed. Obviously, Illinois wants to have any individual who works in Illinois provide them with their day in court. The other thing that it does is it now requires a disclosure for employers of adverse judgments and settlement agreements. So that's a little, I think, overbearing, so to speak, when it comes to that, but it hasn't really been evaluated yet by anybody because these are all coming into play this year. So just something to regret. It's almost like every employer who's in Illinois needs kind of a checklist of what do I have to disclose? What do I not have to disclose? Everything like that. And then finally, for the conviction records,
Question.
yeah. It's on the Illinois Department of Human Rights. There's like a requirement, like a form that you basically have to fill in.
And then it's just housed on their website.
Yeah.
Make the disclosure directly to your employees.
To your employees? No, to the Illinois Department of Human Rights. Yes.
Okay.
Oh, yes. Not, no, don't tell your
Okay.
employees. Sure. And then last but not least is this conviction records. We've obviously seen these over the past few years, this push of really focusing in on people who have been arrested or convicted of crimes. And now, under the Illinois Human Rights Act, a person with a conviction record is actually potentially covered. So the interesting thing is what it has done is create, once again, a type of notice requirement and this interactive assessment that employers have to go through with their employees. So under this kind of conviction record underneath the Illinois Human Rights Act, can you discharge an employee because of a conviction record? Yeah, of course you can. But as with everything else in the employment law, there's a caveat. It has to be related, obviously, to the job. So, you know, we've got people who work in daycares. They've got an assault conviction. Is that probably a reasonable basis? Sure. But what Illinois now requires is before you actually discharge them, you tell them, listen, we're planning to terminate you because of this record. We think it's, you know, it's substantially connected to the job that you actually do. So you've been put on notice for that, and then it allows that employee to engage and try and explain their convictions to the employer. So the employment laws are always about, let's talk about it, you know, employer, employee, let's engage in some type of dialogue to really understand. Now, once you've done that interactive assessment and you've allowed them to talk back, I mean, you've already made your decision, you know, if something changes, I'd be surprised, but you've done what you had to do under the law. But if you don't afford the employee that opportunity, then it could be potentially considered a civil rights violation.